Thanks for taking the time, Chuck and Larry.
I look forward to speaking with all of you and start off sort of very broad, and we'll get into narrow issues regarding the PPP. As most people are aware, the PPP was first started in the CARES Act last April, or last March, implemented last April. In December of last year, in 2020, the president signed a new bill authorizing $284 million of new PPP funds. There's a portion of that which is available for first draw loans, and there's a portion available for second draw loans. Most of it is for second draw, but you can still get loans under the original terms. And there's a distinction there, and I'll get into it in a minute, of who qualifies. But the purpose of the second draw loan, which I think is what has caused a lot of people a lot of interest, is if you had a PPP loan, you spent it all, and now you still need more. Once again, the PPP and both first and second draw are forgivable as long as the expenses are for appropriate and defined payroll costs, and we'll get into that in a little bit. The beauty of the PPP is, A, it's a forgivable loan, meaning it turns into a grant. If it doesn't turn into a grant for you, it's a 1% loan. The loans generally for new loans are 5-year terms at 1%. So even if you can't get forgiveness, it's still a relatively cheap source of capital. And the loan payments, if you had to pay back, are deferred for borrowers for the first year. And they're basically, and then you can seek forgiveness after 8 weeks if your expenses are for appropriate payroll costs. Now, the interesting issue, and it's the same thing in some ways, is that the loan amounts for first draw loans were for the lesser of $10 million, or your aggregate actual payment costs. And what's interesting in your payroll costs, you look at compensation that is only under $100,000. So you would subtract out that excess compensation. In the second draw loans, there's a maximum of 2.5 times, so it's basically 2.5 months, of your average monthly 2019 or 2020 payroll costs, but there's a maximum of $2 million. So the issue is, if you qualify a first draw loan, you can get a larger loan amount. But if you don't, in the second draw loan, you're only going to be able to get the $2 million maximum. Now, there is an exemption for entities that are in the food service or hospitality business, and that's going to be 3.5 times the average monthly payroll costs. But then once again, it goes up to a maximum of $2 million. So they're really trying to keep this focused on small borrowers and make sure there's enough money to go around. Now, one of the other really interesting things in the second draw program is that a borrower can apply in the second round if they returned their money or they didn't use it all from the first round. So there was a lot of issues under the first round loans where people said, oh, you're not qualified, and there were some public companies, and there were some, I won't name names, but there were some well-known food chains that applied for loans. They gave the money back. Now, in retrospect, maybe they shouldn't have, and people had an issue. And so if you return the funds, you can still apply for a second round loan. Now, one of the issues that comes up, and it's similar but a little bit different in the second round. First round, you could get a loan if your small business had 500 employees. And the second round, it's limited to 300. Now, the trick here, and it sort of gets complicated, and this is where a lot of time has been spent. If you have affiliates, meaning you're under common control, or you're otherwise owned, like, for example, by a PE fund as an investor, you would have aggregate all the employees of all the different entities that you're affiliated with. And so it's easy and I'll just give you a quick example. Got a question this morning. Hey, we have 200 employees in the United States. We have 300 employees outside the US. Do we qualify? And the answer is you aggregate all your employees no matter where they are worldwide. And if you're above the 300 limit for the second round, you don't qualify. But the bottom line is you look at all your affiliates and you have to be below the current threshold of 300. If it's a first round loan, it's still 500. So this is really, once again, the theme of the new round is to keep with small businesses.
From the way I'm kind of hearing this is that if you got the loan the first time, or you returned the money the first time, or you had anything to do with the first round, you don't qualify for the first round rules anymore. You must do the second draft rules.
Yeah. Well, if you never got a loan, you can go under the first round rules. Yeah. If you did get a first round last year, you're under the second round rules that only apply to if you have 300.
Okay. And are there any updates to the first round rules now if you never did qualify? Like, is it all the exact same rules as the first time round?
The affiliation rules continue to apply as they were finally done by June or July of last summer after all of the iterations of the affiliation tests. There are some additional limitations which are in the new provisions in terms of saying that companies with Chinese ownership and certain other companies are flatly excluded. Lobbying groups can't qualify. So there's some limitations like that. And my view, it's not clear under the statute, but given the way the new provisions amend the codification of the old provisions, I think those new limitations would be applied by SBA even for someone who had not already received a round one loan.
I agree that they're going to probably interpret them consistently, especially given the intent of the Congress was to put certain limits, and for example, the Chinese-owned companies restriction and the lobbying restrictions.
When's the earliest you must have been around and doing payroll for this to be like relevant? Is it like January 2020? Is that the earliest for like what's the new company rule? What's the earliest you need to be around doing payroll?
I thought it was February of 2020 that you had to be around.
And doing payroll, right?
Right. And one of the other issues is you on the opposite end of formation of a company, you can't be in bankruptcy or out of business to get the loan. And you're going to be making certification. And we'll get to that in a minute. You make certifications to your lender that all these things are true. And just a preview, and people might have heard this before. If you lie, that's a federal offense, and there's lots of criminal actions that can come against you. So this is actually quite serious in that you have to be accurate in your application. So
yeah, just two points on that. You must have been in business not later than February 15th, 2020. So that is the time by which you must have been in business. You must continue to be in business if you're not in business currently, other than not operating because of COVID restrictions. Then you don't qualify. Some of you may recall that there were some issues about companies going into bankruptcy or in bankruptcy seeking loans under the PPP program. Congress resolved that issue by saying a company that is in bankruptcy could be eligible, but you must make a special application to the court. The court must rule that you are eligible, and that loan will then get special priority on repayment, which means your DIP lender is likely to be concerned. So you could qualify if you were in bankruptcy, but the restrictions are such that it's probably not going to matter much to most companies that would be going into bankruptcy.
And the expenses you're going to incur to get the court approval probably are not going to count as payroll costs, meaning you're going to eat those, and it won't be forgivable.
PPP draft 2 has like a revenue qualification, right? That doesn't apply to anyone still submitting against draft 1, right? That's only for draft 2. Is that correct?
There were revenue. I mean, after we qualify in small business under round 1, I believe it was, and I apologize, I don't have that off the top of my head. I think it was you have to have a revenue drop in round 2 of 25% over the previous year. Is that what you were saying, the drop there, or were you saying a revenue cap?
So I'm just saying, if you're applying for the draft one, like the first version of PPP, but now, then the revenue like qualification, like the 20%, 25% decline,
Right,
that doesn't matter, right? That's only for draft two. That matters.
Correct, but in round one, you had to certify that there's an economic uncertainty that you're facing. And ultimately, in the forgiveness phase, you're going to have to justify why you face an economic uncertainty. So it's not just they're handing out money; it's money because, and you have an issue. In draft two, it was sort of simplified. Or round two, they simplified it by saying just demonstrate that your revenues went down by 25% or more, for in all or part of 2020 and compared to 2019, and then that you basically automatically would qualify.
Well, I want to caveat that a bit. It is the case that that's the way the statute reads. The application that at least some of the lenders are putting out for round two continues to have a certification of economic necessity due to uncertainty. So you probably will still be making that certification. As Larry mentioned, all of the certifications are subject to the federal requirements on fraud and not making knowingly false statements to federal officials. So you would have to still make that certification. And in the forgiveness applications, SBA is going back and looking at the economic necessity issue. For loans greater than $1 million, they're in particular looking at, given that money is fungible, whether you made capital commitments, whether you did other things in relation to the time period, so that if you had cash to do capital improvements or do other things, they may well take the position that you did not have an economic necessity.
You justify at the time of the application your economic necessity. So you have a contemporaneous record in your board minutes. This is what was happening. This is why we did it. I commented if you have a board, because this is also available to sole proprietors. And I'm not sure all sole proprietors keep the corporate formalities that corporations do. And self-employed people also are still eligible for round two, as well as independent contractors. So it really covers a gamut of what I would describe broadly of small businesses, companies, sole props, independent contractors, and self-employed folks all qualify. So for example, if you're an Uber driver, you could qualify. And so you just have to be careful there, but the economic uncertainty certification remains from both one and two. The certifications are all the same, and they can second guess you. And what will happen is if you made a false statement, that's one thing. If there's a judgment issue, it's going to be a fight. That's why I'm saying to people and advising clients, justify this in your board minutes contemporaneous with applying for the loan, what your economic uncertainty was, so that you're not scrambling 6 months later when the SBA comes knocking saying, was there really an uncertainty? And so those are some of the differences. One of the other issues that comes up, and this came up in round one, a corporate group in round one could only get $10 million in the aggregate. Now, and so basically, or actually it was limited to, corporate group is limited to 20 million in the aggregate if majority owned by the same common parent. So we have actually had various companies that are commonly controlled, they might be below the thresholds, but they're commonly controlled individual shops or entities in different locations, and they remain limited in the amount of money that can be got as a corporate group. So I don't think anyone in this call might be in that. Hopefully I hope people are in that situation, but if you're not, if you are, you're subject to a limit. If you're not, you'll get there in a few years.
Yeah, if you're a startup and you're like near, like let's just say zero revenue or close to zero revenue for a lot of 2019 and 2020, but you are doing like some payroll or something like that. How does this 25% decline work if you're like zero anyway?
That's a real interesting question. You really have to show, for round two, you need to show the drop. So if you're a startup and you didn't take money the first time, I would argue you should be going for round one money, or basically PPP one, because that's still funded. But if you got PPP1 money and you suddenly made money because PPP was a success and you stayed in business, that's going to be a challenge right now.
What if you were
because
like
you need to show the revenue drop?
What if you went 0 in revenue in 2019 and 0 in revenue in 2020? Like how, and like there's no drop because there was no revenue.
Yeah, the question is, how do you show a 25% drop from 0? I suppose it's difficult. And the answer is that the intent, I think, in the second round program was to help businesses that had been in business in 2019, were making money, and then couldn't in 2020 because of the epidemic. So that the program in round 2 is not really as broad as round 1.
No, I totally agree. And as I was mentioning before, the other exemption, it was always sort of there, but they made it explicit: you can't be a public company. You can't be engaged in activities that are illegal under federal, state, or local law. So, for example, and the easy example is if you're in the cannabis industry, that would be illegal under federal law, but it might be legal under local or state law. You can't use PPP money for that. Also, you can't use this if you're a household employer. And then there's other limitations, and this gets a little tricky and fact specific, but if you're 20% owned by an incarcerated or an indicted individual. So if any of, you're affiliated with anyone who's indicted or incarcerated, it can have an impact on if you qualify for the loan. And the other issue is you can't be delinquent on any other loans to the SBA or any other federal agency. So the more common issue, but it's probably not an issue given all the suspension of student loans. If someone at your company or the owners stopped paying student loans or defaulted on student loans, they wouldn't qualify. But at the end of the day, there's other programs that suspend the payment of student loans. So that might not be the greatest example, but it's what's out there.
Someone's asking this question. I think it speaks to this confusion around round 1 or round 2. If you did not apply for round 1, but you think you qualify now for either round 1 or round 2, you shouldn't apply for round 2, right? You should just go for round 1.
You should go for round 1 money because you can get more money and it's a higher number.
Easier, and it's got slightly easier requirements. So basically, the only reason round 2 is relevant is if you applied for round 1 and got the money.
Right.
Or you got the money and you returned it, but even then, that's when you go for round 2. But otherwise, you go for round 1.
Correct, because the goal here is to keep small businesses afloat, to get through this rough time. And so if you got the round 1 money, you went through it, and now you're back to where you were because you're suffering because the economy is still bad, you can go for the round 2 money. But if all things being equal, if you didn't get round 1 money the first time, go for it now because it's a little bit different.
If you formed a startup, you paused payroll because of COVID, so you had some difficulty, but then you went on to do fundraising, and I assume you were successful. Can you still apply for kind of the original PPP, or does this successful fundraise potentially show that
that gets back to the certification? Is there economic uncertainty? And I'll give you an example. I had a client who was having real economic uncertainty. They were about to shut down. They actually got PPP1 money. They then got an investment because they survived. And basically the question, they were able to get through it with some private sector investment. I would argue all is well. This is exactly the purpose of the program. But the question comes up, hey, should we get round 2 money? We meet the criteria for round 2. Can we get round 2? And that sort of segues into, and I'll pause because it segues into my next set of comments, which is sort of on the forgiveness process. But at the end of the day, remember that in the SBA and your lenders are going to have 2 bites at the apple about that economic uncertainty. There's one when you apply for the loan and you say, I'm facing an economic uncertainty. There's another when you apply for forgiveness. And the forgiveness application is a little bit different, and it depends on the size of your loan. So there's a forgiveness form, I think it's called EZ, sort of like off the taxes, but if you're under $150,000, it's a relatively straightforward process. In round one, if you had a loan that was over $2 million, it was automatically subject to federal audit to make sure you met the criteria, and they would look back at everything you filed. Round two, as we mentioned, the highest amount of the loan you can get is $2 million. So you don't get that automatic audit, but there will be audits of certain round two loans. And in that, they're going to still look at the economic uncertainty and see, did you really have a need? And so in the forgiveness application, you're going to be allowed to have the entire amount of loan forgiven, meaning it turns into a grant. But in round one, you had to keep your employee numbers and your compensation levels relatively in the same manner as you had before. In round two, it's a little bit less or a little bit more ambiguous about whether you can have a reduction in some of your employee numbers, but what's important is what you spent the money on. And really the focus needs to be, this money can only be spent on payroll, wages, commissions, for employees, as I said before, only for people who earn under $100,000. So if you have someone who earns $125,000, the amount forgivable would only be the 100, and you'd be stuck paying your original 125, or the extra 25 is yours. Rent is forgivable. Various leave programs are forgivable. So if you paid vacation leave or parental or family medical sick leave, that all counts as a payroll cost. Severance costs are now covered, and so that would get to, you could have a slight reduction in your force. Your insurance qualifies, your mortgage qualifies, utilities qualify. All those are expenses that can be used, that you can use the proceeds for. And now what they did in round two, given that so many small businesses had to incur expenses, worker protection and facility modification expenses. So putting up plexiglass in your facility, that would count towards what can be forgiven. Damage costs if you were in a riot zone due to the public disturbances of 2020, as long as it wasn't covered by insurance. So that's one of those issues that I'm sure if you claimed, hey, my building burned down because of a riot, and then it turned out you got insurance, that would be caught in your forgiveness audit. Expenditures, they're essential at the time to keep your current operations. So if you have to buy certain equipment or certain ingredients in order to keep running, that would be covered.
If you do round one now, is it the same thing that like you can only have expenses that are like basically payroll?
Yes.
Okay. And then the time period is fairly short for round one forgiveness, right? Like it's like 3 months or something like that. Right?
Well, the forgiveness was originally based on a 2.5 month job. I mean, so when this was first came up,
round two is longer, right? Like
round two really.
You have a period of 24 weeks now within which to expend the funds. And then once you have done that, you can seek forgiveness. The lender has 60 days within which to consider and make a determination on your forgiveness application. SBA then has 90 days thereafter to make its own determination.
Okay. But all those numbers you just said, that's for round two, right? For round one, we still have
both.
Both of them have these
both
kind of
because
things.
CARES Act was amended in June to extend the period. The original CARES Act in March made, in hindsight, a demonstrably silly assumption that the epidemic was going to be over in 2 months. So the original act had an 8-week expenditure period once the loan is dispersed. That was amended in June when it became clear that 8 weeks was a silly number to be a 24-week period, and that is carried over into round two.
Someone is asking, what's Mercury going to do for PPP? We sent out an email with instructions on people who apply through Evolve, which is our partner bank and the one that I think most of our customers used last time. So if you used them last time, we sent out instructions for how to use them for round two. If you didn't use them or you want to use Mercury now for round two or round one, applications. We're going to send out kind of new instructions with this recording later today with another partner for kind of applying for PPP, either fresh or round two, but through us. If you have, well, this person says, I pay myself and I'm an American and I have 2 Filipino employees and I'm applying for first draw. Like, how do you count those employees and do you get any money for those employees?
You count the employees for the number of employees in your company, but you only count the U.S. employees for the payroll cost. You wouldn't get paid for employing someone, for example, in the Philippines.
Yeah, I think that's fairly straightforward. And then this comes up as well. If you know, how does the economic injury disaster loan and like, I guess that class of like loans compared to PPP? Can I apply for both of them? Can I only apply for one?
You can apply for both. The PPP is forgivable. The economic disaster loan is not. But you also have, if you look at the application form, you have to disclose if you have an economic disaster loan, and you technically should not be using them for the same purposes. That would be double dipping.
Right. And the one thing you have to make sure that the amount of loans, it doesn't change your economic uncertainty issue, because if you're covering a certain expense with the economic injury loan, you have to make sure you really do need the money for the other purposes.
Someone asked whether contractors would be considered a forgivable expense.
If they're necessary for your business. So for example, is the easy example I would give, you're building something and you still need to have someone, put a roof on the building before the winter or before the rainy season. That, if it's an economic necessity, that should be covered.
But to be clear, like, you can't use, if I'm paying contractors, you can't use them as like the amount I can apply for as a loan. Like, it's like you have to only use payroll for the amount you can apply.
It really has to be something that's keeping your business alive versus keeping your business running.
Well, I'm saying in the loan application, you can't use contractors as like the multiple that you apply with, but you're saying for forgiveness, if it's like helping you keep.
Oh, are you saying for example, count contractors for your employee numbers?
Yes, exactly. Like both for employee numbers, but also for payroll. Any contractor payroll does not count as like payroll expense.
Correct.
Yeah, the independent contractors can apply themselves.
Right.
So therefore, they are not employees within the meaning of counting them for payroll purposes. Essentially, anybody on payroll has to be effectively a W-2, not a 1099.
It's not just that the company has to be established pre-February 15th. You also have to have payroll pre-February 15th, right?
Yeah, I mean, you're going to be looking at, and it's actually interesting because the 25% language where there's a dip or in your expenses was for more or in all or part of 2020 compared to 19. So you need to be able to show that it went down in a comparison looking at a quarter of 2019. So you really need to have that comparison there. And the challenge is, if you were formed on February 14th, right before all this stuff began, you're not going to have a comparable quarter in 2019. You're only, I think this is the question that came up before, you're only going to have gone up. So there's going to be a challenge there. And that's one of those, there's a lot of inconsistencies in the rules in that you could be in existence on February 2020, but you're not going to have a comparison. And what happened in PPP1, and this is what was frustrating for many, created work for a lot of people, was they kept changing the rules every few days, adding FAQs. So one of the issues, and something that we monitor carefully as well, is as they come up with new FAQs, there's guidance because they consider these questions that come up.
Yeah. Okay, this question comes up reasonably often. So obviously, if you're a normal company, you're doing W-2 payroll through like a payroll provider, it's simpler. What happens if you're like a multi-partner LLC and instead of doing payroll, you're just withdrawing profits. Does that still count? Like, do you just count that total like profits withdrawn as like payroll effectively?
Are you asking if the compensation to a partner in the, a member in the LLC or a partner in the partnership counts? If the person is an executive or a manager in the business which is seeking the loan, then that is part of the compensation. But remember that anything over 100,000 does not count.
These quarters have to be exact, like Q1, Q2. It can't be like 3 consecutive months, right? It can't be March, April, May. It has to be like
I mean, it basically talks about comparing with all or part of 2020 calculating comparing gross receipts in a 2020 quarter. I interpret that to be a calendar quarter, but at the end of the day, that's one of those issues that you could compare July, August, September, especially if you're in a seasonal business. Round one actually, and there is language about seasonal businesses and how things work. So it might not be a real quarter, but that's something that's going to be worked out.
Do you think the lending bank will be making that determination whether
I think the lending bank will push back if they feel uncomfortable. It's interesting because we represent both lenders and sometimes we represent banks, and they bounce questions off, and it's fascinating, the questions of what people ask to do. At the end of the day, the bank will I think they'll use a reasonable standard, but there's a lot of times they ask some really interesting questions, and it's amazing what people try and ask. There's no harm in asking, but don't lie on your application.
Yeah, they were established in 2019, but they didn't run payroll until March 2020. Can they apply?
I don't know why not, because at the end of the day, you're going to have those expenses in 20. And well, I mean, the bottom line is, you can apply under one because you're not you're not having the drop in revenue. Chuck, I don't know if you have a different view.
Well, let's parse it. I mean, if the entity borrower was in business on February 15th, 20, then they meet that qualification. If they didn't get a loan in phase one, then they could still seek a loan under phase one. They wouldn't qualify under phase two. You would look at what their payroll was in the relevant period in 2020. That sets the limit on the maximum amount of the loan, with those proceeds to be used to pay payroll in 21.
And then one last question that'll be relevant to kind of our audience. If you are a VC-backed business, but you can certify you were harmed, there's like maybe you were in like a space, like a travel space or something that's like very obviously harmed. Does the affiliation rule, has that been cleared up enough that like if you have a minority VC, you're probably fine, or are we still worrying about like
that? It's the VCs? Same issue in the second round as the first round with basically the anti-affiliation rules, but except it actually got worse because the new round in round 2 is 300 employees versus round 1 is 500 employees. So that's going to really capture more.
So even if you have a VC that only owns 15%, you probably have to sum up all of their kind of portfolio company employees.
I think it has to be a 20% ownership, and that's a great question. I don't think they really addressed or clarified the ownership issues. It's the same as round 2 as round 1 of what the VC issue is on the anti-affiliation rules.
They have not given further guidance. It's quite clear that a VC by itself does not qualify for the loan. A portfolio company would have to look at the question of whether the VC's commitment to provide operating funds or additional capital raises a question under the economic necessity rule. 20% owners must be listed on the application, but you still have to deal with the question of affiliation and control. Does a 15% owner have, quote, control, close quote, of the portfolio company, so that you then apply the affiliation rules to entities under common control? The issue there is not only what the equity is, but what the so-called negative controls are. There are some negative controls that SBA would see as giving control. If the VC has 15%, but it has approval rights over budget, SBA would probably deem that to be control.
Got it. So you should, in that kind of situation, you should definitely talk to like knowledgeable lawyers to like.
Correct. It gets it's very fact specific. And yet the answer is yes, you should talk to a lawyer at that point for those kind of questions.
Okay.
Now, but I will tell you, one of the things, and I've dealt with this, is does your VC have a capital requirement to contribute further money? That comes down to, we've seen situations where a VC does not have further capital obligations. Then you have to, as Chuck said, you have to look at all the various covenants and negative covenants. Could they really still be in control? But if there is a capital obligation, or you can make a capital call on the VC, you're not going to meet the capital uncertainty test.
Okay, perfect. That makes sense. Okay, yeah, and if anyone is in that situation, does want to talk to Larry or Chuck, just email us at ppp@mercury.com, and we can potentially put you in touch as well. But yes, thanks for taking the time, Larry and Chuck. Thanks for your time, and thanks for everyone attending and the good questions we got. And have a good day.